Hello, and welcome to the Number 5 Planning Podcast. My name is Daniel Henderson, and you join me today for the second of our special two-part series on how to do hearings. Last time, we looked at the process as it would appear to an appellant, and we explored the process from start to finish, offering our thoughts along the way as to how you can make sure you're presenting your best case at a hearing. Today, we're going to do the same thing, but from the very different perspective of the local planning authority. And to do so, I am again joined by two planning and environmental barristers at Number 5 Chambers, James Corbet Burcher and Sioned Davies. And we started by envisaging the scenario that you, as a local planning authority officer, are going to be faced with. A statement of case and all of its appendices lands on your desk, and you've got a lot of work to do quite quickly. So I started by asking James to take us through what you need to be thinking about at the outset, starting, most importantly, with the questionnaire.
You need to basically set out the timetable of all the different documents, processes you're going to have to engage with, starting very much with the questionnaire and the individual documents you have to attach to that. There's a range of them. I'm not going to go through all the specifics of that, but fundamentally it'd be obviously the consultation responses, elements of the development plan. It's our strong view amongst the podcasters here is that you probably want to be putting in the whole version of that. But if you want to put excerpts in as well, then that may be something which could help on that front. But you put the questionnaire in early on and then rapidly then move to compiling your statement of case.
So your statement of case is what you draft in response to what the appellant has drafted, and it should remain faithful to what the reasons for refusal say in particular. Obviously, if there is an officer recommendation for refusal and then a reason for refusal, it might be that you can base it on what the officer's report said. But if there's been a committee overturn, that might not be the case. So really flesh out your case, honouring the reasons for refusal and trying to grapple really with what the appellant has said in their appeal statement.
And it is really important to grapple with that as early on as you can for two reasons. First of which, Sioned has already identified that we don't in statements of case want to be taking new points. We don't want to start to expand upon the reasons for refusal. We don't want to start, unless there are really exceptional circumstances, adding reasons in to oppose the development. And the second reason is that if, for whatever reason, you, on further reflection and consultation with your team, decide that a particular reason for refusal doesn't have as much merit as you might think, or that circumstances have changed, or that something that the appellant has put in their statement of case changes the position materially, the statement of case is the first opportunity you have to set that out to be sensible, proactive and clear. And if you're not going to defend a reason for refusal, to say it at the earliest possible stage.
That's particularly important, bearing in mind the dynamic and transitional nature of where we're at the moment in the context of the new MPPF, but also throughout this year in the context of changes of policy which will emerge as more and more guidance and potentially national development management policies are brought forward by government.
I think, you can reflect on your case early on, and if you do think that there are reasons for refusal which are simply indefensible, then it is important that you really seriously consider dropping them at the statement of case stage. My experience is that many authorities have delegated powers for officers to make those kinds of decisions themselves, but if you do need member approval in order to do that, then obviously the sooner you're able to take those decisions, the better, and it's less likely that you'd face cost consequences as a result of that.
And that's why, and this may become something of a running theme through this podcast, early engagement and making sure that you have a team around you and that you know who that team is, ultimately the hearing that's going to feed into the different reasons for refusal that you're going to defend, is important to get sorted as early as possible, particularly if you are in a local authority context thinking about whether, depending on the consultation responses you received from particular fields, you may need to look elsewhere, you may need to look for outside support. The most important thing is to work that out early, because all of the opinions that you get and the professional guidance that you get from those people is going to feed into your statement of case. The statement of case, much like an officer's report, is going to take the professional advice that you receive and it's going to concertina it into a single document that sets out why you continue to oppose the appeal. So an early meeting, getting everybody together and talking very clearly and understanding what your case is going to be really important.
Some topics lend themselves very naturally to the sharing responsibilities, notably housing land supply. If you are facing, in the context of a changed housing requirement, and inevitable passage of time, changes in respect of the deliverability of given sites. Very important that the officer who is on top of those issues and monitors them is available for the hearing and can assist the inspector in dealing with those issues as clearly as possible at the hearing itself, freeing you up as the planning officer to deal with the other questions of development management.
Yeah, I think it's also really important to reflect early on whether or not you are able to give evidence. It might be that you've written a glowing officer's report, which has subsequently been overturned by committee members, and ordinarily it's difficult to then sit in a hearing and say something which is entirely contrary to that which you earlier wrote down in an officer's report. And the same can be said of lots of the individual witnesses. So say, for example, you've had an endorsement from the landscape officer, but members have sent the scheme down on landscape reasons for refusal. It would be very, very difficult then for the same landscape officer to sit in the hearing and say something which entirely contradicts what they'd written down in their consultation response.
I completely agree. This idea of it being an informal hearing can sometimes, as I said in the earlier podcast for appellants, it can sometimes lead one into the position of thinking, well, maybe there's an informality in the procedure, and that's absolutely not the case. There is still the stricture, the formality which attaches to the giving evidence and the credibility of the presentation of that evidence. And so if it needs to be a new officer or an external consultant delivering evidence on that issue, then you need to have that conversation internally with the local authority to make sure that it is someone fresh who can give their own fresh judgment on those issues.
And that feeds into the other major document which you're going to be producing in concurrence with your statement of case, which is the statement of common ground, because those who are ultimately appearing for you at the hearing are going to be those who feed into the process of that. So as a local authority, the advantage that you have to some extent is that you are going to be served with a draft statement of common ground by the appellant, and you're going to have the advantage of being able to prepare that statement of common ground or respond to it as you set out your statement of case. So those two thought processes, which should be quite closely aligned, will be happening concurrently. I think often it's practicalities that trip people up more than anything else. Top tip, please track changes. Track changes make an enormous difference, I think we've all come to find.
That's an express requirement of the PIN's guidance on statements of common ground to track change, but also there's a strong recommendation there to use margin comments to explain the differences which you've reached. So rather than just a single line deletion, there ought to be something neutrally expressed in the margin comment to say why you've issued that deletion, and where relevant, what alternative text you think should be included in its place.
So after you've received the appellant statement and you've, together with the appellant, been working on the statement of common ground and submitted your LPA's appeal statement, you may well receive further evidence from the appellant. This should only really be issued in exceptional circumstances, but it's certainly not outside the realms of possibility that that will happen. So you need to reflect on how any rebuttal evidence impacts the case that you'll be running as the LPA.
Don't just sit there and say, well, it's all been issued after the deadline, I'm not going to engage with this. The practical test, in accordance with the PPG appeals guidance, is essentially whether you've got sufficient time to address this such that it obviously wouldn't cause any disruption to the procedure, and in particular having regard to whether some of this information may be information which could not have been produced any earlier. So you need to be prepared if it is arrived at a reasonable amount of time prior to the hearing to actually engage with this and acknowledge that the inspector may well accept it.
That's absolutely right. Once we're then in that stage between the submission of a statement of case and the hearing itself, what are you as a local planning authority officer doing in terms of preparation for the case? Before you get to the last few days before the hearing, I think, as you were touching on, James, it's important as a local authority to be aware of the fact that there may well be developments in your local area in terms of national or local policy changes, or just in terms of matters changing on the ground that you may need to bring to the inspector's attention if things happen in the interim. I've certainly been in situations in which local authorities had perhaps other appeals that have dealt with policies that are in issue in the course of a hearing, or that have dealt with materially similar developments in the area. So it's not a case, is it, of once the statement of case has gone in, sitting around and waiting what is often a fairly long time for the hearing to roll round, it's something that you need to be having constantly on the back burner.
For me, I think the critical thing is knowing when you're going to meet the team. So when you're an LPA, I think you need to meet shortly after the statement is received from the appellant to discuss the contents of that statement and divvy up work between the relevant witnesses to compile your statement. But I think it's also important to meet later in the process, i.e. before the hearing, again, just to make sure that you have tied up any loose ends. It might be that there has been rebuttal evidence served by the appellant, and you need to reflect on how that impacts your case as the LPA.
I think the other thing that it's important to point out, even though it might sound mundane, is just the practicalities of the appeal hearing itself, which can make an enormous difference to everybody involved. You'll obviously have had to think about venue some way in advance, but it's the little details that can often make a big difference. So making sure that well in advance PINS is aware of or has some sense of the likely level of local interest, and therefore how much time might need to be allocated for interested parties to speak. Making sure that the venue has breakout rooms where teams can go and meet. Making sure that all the practicalities are there is the sort of thing that takes a little bit of thought, but can actually make an enormous difference on the day. I know in the context of the podcast that we did for appellants, we were talking in particular about having printed copies of things, which can make an enormous difference.
Yeah, I think treat it as close as you can to an inquiry, acknowledging that you won't be able to address issues in the subsequent days of the hearing because there is only one such day. And recognise that in the particular policy climate we're in at the moment, that hearings will become more popular for schemes of a certain scale. And therefore, you're going to have to face more hearings, more one-day hearings, than just individual inquiries taking place over multiple days.
I've certainly had a number of schemes which have been downgraded from inquiries to hearings in recent weeks. I was also involved in a scheme recently which was very locally contentious, and lots of local people didn't necessarily want to speak, but they wanted to know what was going on in the hearing. And so the local authority in that case took the view that live streaming on YouTube was a proportionate and reasonable solution instead of trying to accommodate lots and lots of people in the room at the same time. So that can also be an option where you foresee that there is considerable local interest in a scheme.
And that rather brings us on to document management. Now, in the context of inquiries, obviously, it's a requirement to produce a list of core documents, to have those core documents neatly numbered and presented in a suitably accessible way. We don't have, because it's not the same requirement or the same, certainly, length of practice, the same consistency of approach in respect of hearings. But I think we'd all agree that certainly hosting documents online so far as possible and in as clear a format as possible can make an enormous difference to everyone.
Absolutely. I think something we observed in our earlier podcast is that you might want to encourage the appellant to host separately the hearing documents. It's certainly a requirement to do so, but it's been found in the inquiry process that hosting them in your own portal, be that a SharePoint or similar function, can assist parties and just help an inspector and interested parties get everything they need to in one place.
Absolutely. So that's all set up. We've got our nice online portal. We've got all the documents in the right place. Then we come to the hearing itself. This is a topic that we've also touched on in the context of our earlier podcast, but it's an important one, particularly if you are a local authority officer who is perhaps heading up a team of other local authority officers, or if you are the officer with a barrister instructed as well. In those scenarios, how are we dividing up time and how are we dividing up responsibility, particularly on those slightly greyer areas? James, you touched on housing land supply earlier, that perhaps blend policy and practice a little bit more.
If you have instructed a barrister, it's important to understand the limits of what they can make submissions upon. Obviously, they can assist on the law, they can assist on points of interpretation of policy, they can assist on various points which are closely related to the law. So, for example, the principles you would apply to dealing with an application site which is adjacent to the appeals site, matters like that. But ultimately, and this is about the core understanding of the responsibility that the local planning authority faces, you as the officer are there to articulate fully the merits issues, why permission has been refused in this case and not granted. And so it's you as the officer that needs to work out from a very early stage, including through drafting your hearing notes, what exactly do you want to say on the day?
And as we touched upon in the earlier podcast, a barrister can really help you frame the narrative. So they can't tell you what to say or influence your evidence in any way, but they can really help you identify what the best points are. And they're the points that you should really focus on. Another practical point, which inexperienced witnesses often ask me about, is the extent to which they will be able to speak. So an inspector will normally ask a question, typically of the counsel, what's your issue with X? There will be a response from the appellant, but often you can come back on those points, so you have a further opportunity to elaborate on your earlier concern.
And it goes to the point that you were making in our previous podcast in terms of the format of the way these hearings tend to work. You will potentially be in a slightly unusual position if you are for a local authority, because you will be squeezed in the middle in terms of the evidence you give between the appellant having two goes at it. The appellant on all topics really ought to have the final word. And so can feel a little unequal, and it can feel, particularly if you have quite a large appellant team with a lot of professional consultants, like there's something of an inequality of arms. But I think the important thing to remember, whether or not you've given evidence at an inquiry or an appeal before, is that what you're doing is conveying information to somebody who will have asked a very specific question and who will want your response to the points that are raised by the appellant's witnesses. So absolutely right, James, to point out that what we need to be thinking about is exactly the points that you want to make, and to set those out very clearly to ensure they're not lost. But also you do need to remember that what you're doing is responding when you're asked questions in the context of a hearing. An appellant will set out the reasons why they say you are wrong, and you are ultimately going to be tasked with responding to those. So it's important to remember not simply to stick to a script. If an appellant witness brings up a point that you hadn't intended to deal with, don't leave it, don't bat it away, don't think it'll go away, don't hope it'll go away. Deal with it, because the inspector will want your assistance on it.
Indeed, that may be where you want to start. Is about thinking, well, what's the worst question the inspector could ask me at the hearing, and then set out your 3 bullet points that you would give in response to that. Remember that given the context of what many inspectors' professional backgrounds are, whether they've been in the private or the public sector, many of them will have been in your position, and they understand the role that you are performing as a witness. And if you think consistently about how you can help them, then you're going to be on the right track, fundamentally, for delivering the evidence that they need and they want to hear.
I think it's also worth noting, because this is something that I've often had asked to me of local authority, particularly planning officers, is that inspectors will often have been in your position, and then therefore they'll know that on the day of the hearing itself, you're going to be wearing many hats. You're going to be in charge of an awful lot of the practicalities of the situation, while also having to keep your focus firmly on the evidence that you're going to have to give. So I think it can just be reassuring to know that people will be aware of that, and will take that into account if you need time to go and look at a point.
There's a few ancillary points as well that you'll want to think about on the day. We referred to a number of these in our earlier podcast for appellants, but I'll list them again at this stage. It's important at the very outset to confirm the list of plans that the authority determined the application on. It's important to keep a good list of what's been submitted by way of additional documentation throughout the process, so you can check that the inspector has actually before them something that was submitted at that time. And also engage with the appellant in respect of the site itinerary to make sure that you both parties are agreed where the inspector may wish to go post the hearing. We talked earlier on also about conditions as well, and the engagement of an officer in the conditions process.
Yeah, obviously it rather depends on the situation and the basis upon which the hearing has proceeded. Obviously, if it's a member overturned, there will very often be a list of conditions that you've drafted as part of your report. But I think the thing to bear in mind, which is the concomitant of what we pointed out in the podcast that we did for appellants, is that they're going to be scrutinised much more heavily by the inspectorate at a hearing than they would be previously. My top tip for local authorities dealing with these would be to liaise with the planning consultant for the appellant as early as you can to try and resolve these issues, because you as a local authority have got to be aware that if permission is granted, you want to get the best development that you can and to minimise what you view as the harm. And if you don't engage early, and if issues arise with conditions at the hearing and you get appellants ambushing you with points about the necessity or the proportionality of certain conditions, it can be difficult to respond on the hoof. So it's very, very useful to open that conversation early. try if you can and flesh out any differences in advance of the hearing, and just be aware that the edges of those conditions will be tested by the inspector and by the appellant.
So just a final point then in relation to costs. Should you be in the unfortunate position where you have a costs application made against you as the local authority, they will obviously have to make that application before the end of the hearing. I personally don't think there's any shame in asking the inspector for time to deal with the application. So I would ordinarily ask an inspector for a few days to be able to reflect on what the costs application says and to respond in writing. If you are in the position where you're having to respond on the hoof, i.e. on the day, really focus on the tests in the PPG. Focus on why your conduct has been reasonable, and if you feel the need to adduce evidence in order to show why your conduct has been reasonable, then feel free to kind of append that to the costs response. So, for example, if they're accusing you of not engaging, then if that isn't the case and you have actually engaged by email, then make sure you append those emails to the costs rebuttal.
Let's then try and summarise where we've got so far with some top tips. I think my top tip, and it'll sound a little bit like the top tip I gave to appellants, but it's important, is get your team around you as early as you can, because it can feel something of an intimidating process when you, as the planning officer, having gone to all the effort of writing a lengthy report, then gets landed with a detailed statement of case, potentially appended appeal statements from a number of external consultants. It can feel like a lot, and there's quite a lot to do quite quickly at a time when local authorities are already under pressure. So work out who your team is early on and get their input as far as you can. And if you do need to go external, do that as soon as possible.
I think my top tip is to focus on the best points and drop the bad points as soon as possible. You can do that through statement of common ground, but through critically evaluating your case all the way through. So making sure you're really thinking, what is my response to this if the inspector asks a difficult question, and making sure that you're prepared for that.
My top tip is think hard about national policy. Move with the times. We are in a situation now where there's been a significant amendment to the National Planning Policy Framework that has substantially altered how a number of development plan documents are to be interpreted and applied. And therefore, if your position in resisting an appeal no longer sits with the general thrust of national policy, then think very carefully about which aspects of the appeal you wish to defend, and critically what national policy advises in respect of how the balance is to be struck. And engaging with that process from the very earliest point of receiving the appeal, that you're going to ensure that by the time you get to the hearing, you have the clearest possible case for why permission should be refused if that remains the local planning authority's position.
Brilliant. Thank you both very much indeed. Well, there we go. That brings us to the end of our two-part series on how to do hearings. We hope that those for whom hearings are fairly new found it helpful, and that you can take away some useful tidbits back to the appeals that you're dealing with, and that you're a bit more familiar with the process as it goes through. And we also hope that some of the more old hands at these sort of things found some useful tips in there too. Coming up on the Number 5 Planning Podcast, we're going to be looking at some important recent Court of Appeal decisions by way of update, and looking at some of the implications for applications and appeals on the ground, including the much publicised case of Mead realisations. And we're also going to be back in the near future with another short series on our how to do format of appeals, this time dealing with inquiries. So watch this space.